Hello, everyone. Thanks to over 200 participants who are joining us today for this roundtable discussion on the International Criminal Court's 20th session of the Assembly of States Parties. My name is Milan Asterio, and I'm the Managing Director at the Public International Law and Policy Group, and also the Charles R. Emmerich Jr., Calfee, Halter, and Griswold Professor of Law at Cleveland State University's Cleveland Marshall College of Law. I will be moderating today's roundtable, and am honored to be guiding the conversation with these experts. The Public International Law and Policy Group is a global pro bono law firm providing free legal assistance to parties involved in peace negotiations, drafting post-conflict constitutions, war crimes prosecution, transitional justice, and human rights documentation. In the past months, our team has been fostering the development of a thought leadership initiative. This initiative focuses on a range of topics, from prominent international law issues to pressing global conflicts. Through organizing periodic roundtables, our aim is to share expertise and reflections from our work on peace negotiations, post-conflict constitution drafting, and war crimes prosecution. The Assembly of States Parties functions as the management oversight and legislative body of the International Criminal Court. It is composed of representatives of states parties that have ratified or acceded to the Rome Statute. Currently, there are 123 ICC states parties. The Assembly of States Parties convenes annually in November or December on a rotating basis in The Hague, the Netherlands, or in New York City in the United States to decide and discuss pertinent matters for the functioning of the court. The 14th Assembly of State Parties decided that rather than changing venue each year, the Assembly of States Parties would be held for 2 consecutive years at The Hague and once every 3 years in New York. The 20th session of the Assembly of States Parties this year took place in The Hague, the Netherlands, and concluded exactly a week ago. PILPG actively followed and reported on the key decisions, discussions, and side events. Some of the agenda items and issues addressed during the 20th ASP session included the independent expert review of the International Criminal Court and the Rome Statute system, the election of the deputy prosecutors, cooperation, the trust fund for victims, and the court's budget as every year. In today's expert roundtable, we will be discussing these major topics, key decisions, and takeaways from the session, how these results may impact the future of the International Criminal Court and its work, and other key items currently on the court's agenda. The roundtable will be 60 minutes long. Our esteemed panelists include Dr. Brianne McGonigal-Lai, Professor Jennifer Trahan, Jacqueline Nasiwa, Owiso Owiso, and Emma Bacum. Today's event will be recorded and subsequently posted on our website. We ask that you please submit any questions you have for our speakers using the Q&A function, and we will do our best to answer your questions at the end of this event. Now, let me introduce our panelists. First, we're honored to welcome Dr. Brianne McGonigal-Lai, a senior legal advisor with the PILPG and an associate professor at Utrecht University in the Netherlands, specializing in human rights and global justice, with a focus on victims' rights, transitional justice, social justice, and the documentation of serious crimes. She's a member of the Netherlands Institute of Human Rights, the Montaigne Center for Rule of Law and Administration of Justice, and the research platform Contesting Governance. She's also an executive editor of the Netherlands Quarterly of Human Rights and coordinates the education program of the Utrecht Center for Global Challenges. Warm welcome also to Owiso Owiso, a lecturer in public international law at the University of Groningen Faculty of Law and a doctoral researcher at the University of Luxembourg. We're also excited to welcome Professor Jennifer Trahan, who's a senior peace fellow at the PILPG and clinical professor at NYU Center for Global Affairs. She has written widely on the ICC crime of aggression and is currently convener of the Global Initiative for the Prevention of Aggression. She also is one of the US representatives to the International Law Association's Use of Force Committee and co-chair of the ICC committee at the American branch of the International Law Association. She's additionally pleased to have served on the Council of Advisors on the application of the ICC's Rome Statute and cyber warfare. We also have with us Jacqueline Nasiwa, Senior Peace Fellow at the Public International Law and Policy Group, and the National Director for the Center for Inclusive Governance, Peace and Justice. Jacqueline is a member of the technical committee appointed by the Ministry of Justice and Constitutional Affairs in South Sudan to facilitate public consultations in the process to develop legislation for the Commission for Truth, Reconciliation, and Healing. She's also the chairperson of the National Alliance of Women Lawyers of South Sudan. And last, but by no means least, we have Emma Bacum, Assistant Counsel at the PILPG, and a lecturer at the Free University in Amsterdam, where she coordinates the International Law Clinic. And for our audience members, Emma was actually able to be at the ASP this year in person. For full speaker biographies, please visit the PILPG website. Welcome everyone, and thank you for agreeing to participate in today's panel. Let me begin my first question to Owiso. Could you please tell us a little bit about the 20th session of the Assembly of States Parties, and according to you, what were the major points of discussion at this year's ASP?
Thank you very much, Melinda, and it's a pleasure to be here. It's almost midnight here, but I'm happy to be here. Well, the ASP is often an interesting event normally, but that depends really when it's an election cycle. So it's actually more interesting during election cycles, and this was one such year. So going off on that, for me, I think the most interesting aspects of the ASP 20 included first a number of elections that were held. Specifically, there was the election of the deputy prosecutor, which I found quite interesting. I believe many people did, and I suppose I will say a few things about that later on in the process. There was also the election of the advisory committee on nomination of judges, which of course is also an interesting mechanism and a very important mechanism in the sense that it advises the ASP, the states, on the qualifications of the judges or candidates who are nominated for judges. So there was an election to constitute the advisory committee on the nomination of judges for the next election of judges, which I believe is sometime in 2023. There was also an election of the members of the board of the Trust Fund for Victims, and the Trust Fund for Victims, of course, is also a pretty important appendage of the Rome Statute system. And of course, I suppose I will say a few things about why this particular election was very important for the Trust Fund for Victims and the whole Rome Statute system, the whole Rome Statute system as a whole. And of course, I find these pretty important, especially the election itself, when you consider how much work the court has done and how much work the court is yet to do, and if you project what the court's workload or calendar will look like in the coming years. And of course that ties into the budget, because every ASP the ASP has to adopt a budget. So there was something significant in this year's budget, in that it was the first time in a while that the ASP actually increased the budget of the court. But there's a lot of stuff that gets hidden in detail. So when you say the budget increased, but then by how much did it increase? And yeah, I mean, I do have a number of things to say about that, but I think I'll park that for later on in the discussion. But I found that also pretty interesting because there was a slight increase in the budget. So we'll have to look at that vis-a-vis what the court is expected to do going forward. There was also quite a bit on voluntary cooperation and cooperation in general between the court and state parties and the court and non-party states. There was a few interesting statements in there, and maybe I'll just check this at this particular point. There are a few interesting things noted in there. Of course, the generic call to state parties to enhance cooperation with the court, because there's at the moment, I believe, 12 outstanding warrants of arrest. So the court the ASP went into this whole spiel, what they normally do, of encouraging states to contribute, but to enhance that particular cooperation. But two very interesting aspects for me when it comes to the resolution that was passed on cooperation is one that relates to the defense, and then the second one that relates to asset tracing of assets for purposes of freezing and seizure. First, the shortest discussion in that resolution, it's pretty long, is on the defense. It's just one paragraph of 3 lines, well, 2.5 lines to be specific. So it simply encourages states to look into mechanisms of proper cooperation with the defense, and not necessarily with the defense, but with requests that the defense sends to states through the court. So that is the extent to which the ASP 20 engaged with the question of the relationship between the defense, states, and the court itself. But if you look at the past number of years, the defense has been complaining about so many issues, ranging from taxation to human resource issues to sexual harassment issues, because they're not properly integrated into the court system. So there's quite a lot that the defense has been complaining about. If you look at the independent expert review report, quite a lot. But in this case, in the ASP 20, the states saw it fit to only address the defense in one line, one paragraph of 2.5 lines. So that was quite significant. But then there's also, of course, the discussion on the independent review mechanism, the report that was issued in 2020. That also stood out. But I think I'll also park that for later discussions.
Thank you, Jennifer. What can you highlight for us during this year's ASP, and in particular items that you think are relevant regarding the current developments at the court and perhaps the near future of the court?
Thanks, Milena, and it's a pleasure to be on this panel. I think we're at a place where the court's workload is potentially the busiest ever, with potentially 5 trials next year. So there's just a lot of situations the prosecutor's proceeding in. I will note too, that's not to be moving forward. So of course we have the closure of the preliminary examination related to Colombia. And there was an interesting side event, actually still this week after the ASP, by FIDH on complementarity and Colombia. And of course, the difficulty with closing a preliminary examination is I think it really reduces the court's potential leverage to prod a national country into doing complementarity and potentially doing the cases itself if the national country does not suffice. So there's some real downsides to closure of a preliminary examination. Of course, in terms of the United States, we had the announcement this fall that the prosecutor would prioritize the investigation of the Taliban and ISK crimes. This basically means deprioritize looking at the crimes by US nationals in Afghanistan and secret prisons, basically torture, a program well documented by the US Senate Select Committee on Intelligence. And I think this is very concerning because, again, that kind of pressure to do complementarity is then really squandered. So the US did make a positive statement at the plenary, and this is of course very welcome after the years of Trump administration sanctions, and it's a breath of fresh air to have a different administration present at the ASP and to have a different administration present. But I will say it does come on the heels of the prosecutor backing off the US in terms of the Afghanistan investigation. So there have been interesting side events on ecocide, not only at the ASP, but elsewhere. It's a very timely issue, certainly. Just from a jurisprudential standpoint, I will say that there isn't a lot of, law behind this in terms of, jurisprudence or statutory law, and the Rome Statute is generally thought to codify customary international law. So, if ecocide is going to come online, this might be what we call a Grosjean moment. It might be sudden accelerated formation of customary international law, because the fact it doesn't have this background I think is something of a challenge. I was able to participate in another side event talking about cyber attacks and the Rome Statute. And this marked the launch of a report, and I'll put the link in the chat. It's by the Council of Advisors report on the application of the Rome Statute of the International Criminal Court to cyber warfare, prepared by the Liechtenstein mission, but co-sponsored by 10 states and the Global Institute for the Prevention of Aggression. And I think the report is really significant. And what we're saying in the report is that without any kind of amendment, certain cyber attacks are simply covered in the Rome Statute. And depending on the context, could be genocide, war crimes, crimes against humanity, or the crime of aggression. So potentially falls in any of the 4 crimes, either a cyber-enabled attack, so blended conventional and cyber, or a pure cyber attack. So anyone interested in that, please read the report. And I think this is a really important reflection that it falls within, the cyber attacks can fall in the Rome Statute. And we hope that the ICC takes note of this report. We were happy to have a member of the ICC OTP as an expert in our roundtable, so that was very helpful. And of course, they are at work on a Tallinn 3.0 manual, so we're also hopeful that this can feed into that process. So I'll stop here. Thanks.
Thank you. My next question is for Emma. Emma, were there, in addition to some of the issues that Owiso and Jennifer have highlighted for us, were there any other groundbreaking decisions or developments during this year's Assembly of States Parties?
Thank you very much, Milena. First of all, it's a pleasure to be on this amazing panel to discuss and reflect on the ASP. And likewise, it has been a pleasure and honor to attend the ASP at the World Forum in The Hague on behalf of PILPG. And so I'm happy to be here today to share some thoughts and updates surrounding the ASP. Turning to your questions, first of all, I think it was an interesting ASP to follow, in particular because it was the first ASP with the new prosecutor, Karim Khan, as well as the first ASP with the new ASP president, Sylvia Fernandez Ducamendi, presiding over the session. And while perhaps there were not really any groundbreaking decisions this year, the ASP did definitely decide on important matters for the court, which will inform and influence its functioning in the coming year. And I think from having attended last week's 20th session, there are three main decisions that are relevant to share here today. And Owiso already touched upon the first one shortly, but the first one is definitely the budget. As we know, each year the ASP decides on the budget for the court for the upcoming year. And this year the ASP approved the budget of about 154 million euro, which is an increase, as Owiso already noted, from this year's 2021 budget. Yet it is significantly lower than what the court has asked for and what the Committee on Budget and Finance had recommended. So this will inevitably have an impact on the functioning of the court for the next year as well as beyond. And I think as a second relevant decision, I refer together to the three resolutions adopted by this year's ASP. So first, the ASP adopted a resolution on cooperation, which is a standing discussion item during the ASP, and which it usually does. And this resolution covers several aspects of cooperation and stresses, as usual, the importance of effective and comprehensive cooperation and assistance by states parties with the court. And two additional resolutions were adopted that relate to the independent expert review process, through which the ASP decided to extend the mandate of the review mechanism established during last year's ASP, which is to assess the implementation of the recommendations included in the report. And I think we'll get back to that later in this session as well. One of those resolutions also decided to continue consultations towards the development of a vetting process for all elected ICC officials, which is also a continuing important and interesting topic discussed during the ASP. And I think the third important decision made by states parties this year was the election of the two deputy prosecutors, both elected for a nine-year term. Prosecutor Khan submitted the list of two lists of three shortlisted candidates to the ASP beforehand, and last week Friday, the states parties elected Mr. Niang from Senegal and Mrs. Khan from Fiji as the new deputy prosecutors. And I think it is interesting because this election means that the OTP is returning to the model of the two deputy prosecutors that the OTP also had during its initial years, when there was one deputy prosecutor for investigations and one for prosecutions. And also interestingly, this goes against the recommendations of the independent expert review report, which concluded that the OTP's reasons for appointing two deputy prosecutors, such as including more gender and geographical equity within the OTP, do not really justify the additional expense that come with this. In addition, there were some concerns with the defining of the roles and responsibilities of those deputy prosecutors. So I think it will be interesting to see how and with how much clarity the roles will be divided between those two deputy prosecutors. Finally, I think a notable development during this year's ASP, in my opinion, was the absence of the publication of the OTP's annual report on preliminary examination activities. Previously, Prosecutor Bensouda and her team would launch this report and in the margins of the ASP and present it. And this would usually be a very well-attended side event, as the report forms a crucial way to keep victims, affected communities, as well as stakeholders in situation countries informed about the process of preliminary examinations. So I think it will also be interesting to see if and how Prosecutor Khan will take approach to reporting on OTP activities moving forward.
Thank you, Emma. And actually a follow-up question for you, since you were actually there at the World Forum at The Hague. This year, attendance was a lot more limited. And so what are your impressions regarding this? And are there any behind the scene insights that you can share with us? You know, for those of us who have been here, oftentimes relevant things happen like at the cafe as you're eating those delicious Dutch sandwiches, right? So this year, with the attendance being so limited, was there any of that happening? And what were your impressions regarding those behind the scenes conversations that normally take place?
Yes, thank you. I guess I was one of the happy few to be able to attend at the World Forum in The Hague. And yeah, this year, once again, was very different due to COVID restrictions. And so the presence at the World Forum was very limited, with only 16 representatives of civil society at any given time. But not only a limited amount of civil society representatives, I think there was also fewer and smaller states parties delegation that attended in person at the World Forum. I mean, the positive side of these restrictions is increased transparency when it comes to the ASP, with everyone being able to follow and watch back the plenary meetings at the ICC's YouTube channel. But I think because of this kind of hybrid format, as well as the side events being online, perhaps debates and discussions were not as lengthy as what we have seen in the earlier years. And so there wasn't also as much behind the scenes discussions that I did attend as a civil society representative. Several states parties delivered pre-recorded statements during the general debate, as well as during discussions on cooperation and the independent expert review process. And I think several cross-cutting issues were mentioned that, you know, we will continue to raise throughout this panel. One of which I think noteworthy is also the workplace culture, which I think many people are curious to see how the court and the OTP will continue to address. Not too many behind the scenes insight, however, this year, and hopefully next year's ASP can take place in person again to allow for more additional productive discussions and civil society engagement with the ASP.
Definitely. Some of us, you know, definitely look forward to coming back to The Hague and attending the ASP in person. My next question is for Brianne. And actually, Emma alluded to this, you know, workplace culture is one of the things that was addressed in the independent expert review of the ICC. And Brianne, I wanted to ask you about the importance of implementing the independent expert review. You know, we all know that the review was very lengthy and there were many recommendations in it. So how do you go about implementing this? And actually, was any of this discussed during the ASP? Were any of the implementation, you know, challenges or modalities discussed during this year's ASP?
Thank you, Milena. Yeah, that's a really excellent question. I mean, the independent expert review was certainly on the forefront of everyone's mind going into the ASP and leading up, and still is. So for those of you who don't know, as Milena mentioned, the independent expert review was very lengthy. In fact, it recommended 384 recommendations. So that's extremely substantial. And so at last year's ASP, they had set up a review mechanism and to specifically look at these recommendations and to look at the implementation around them. And as Emma mentioned, a very positive aspect of this ASP is that they've extended the mandate of that review mechanism in terms of its implementation. So some of the key recommendations or topics around the recommendations related to, like you said, workplace culture, the low morale, internal distrust, the harassment issues that had been raised across the court, issues of gender equality, judicial ethics, etc. What we have seen is that the court in early December around the ASP, during the ASP, released its court-wide strategy on gender equality and workplace culture. And what's very welcome is that they are open to consultations on this. And in fact, those consultations are open through March of 2022. So civil society actors are certainly going to have input on this document moving forward. And I think that's very welcome that they are open to these. But this review mechanism will be facilitating its work further, which is great news, because the recommendations, were very concrete around these issues. And it does seem that with this new prosecutor, with the new deputy prosecutors, while there's a little bit of frustration, let's say, at the budget that was approved, because as was mentioned, while it's a little bit more than it was last year, it's much less than what was requested. And the prosecutor has been very vocal about the fact that we need to be honest and realistic about what can be accomplished. And that goes for what can be accomplished both externally and internally within the court. So keep your eyes open, particularly on issues of the gender equality and the workplace culture. But this is something very alive and that civil society can play a big role in at the moment.
Thank you. Owiso, my next question goes to you. You already mentioned the election, or somebody else mentioned the election of the two deputy prosecutors, which is a very important item on the agenda of this year's ASP. Owiso, how were these elections, or were these elections different from the elections held in the previous years?
Yes, they were different, but I'll mention just two aspects in which I think they were quite different. First, the idea here was to increase or enhance the gender representation in the top echelons of the court, considering that the fact that the president of the court right now is a man. The prosecutor was elected last year. Karim Khan is a man. The registrar is also a man. And if I recall correctly, Karim Khan had, he undertook to ensure that he has two deputies. And of course, it's not up to him who gets elected, but so he made that particular commitment to have two women as his deputies. So what he did is he submitted two lists, of course. So one basically called the gender list, which was list A, I suppose. And then, of course, because the court, if you read the IER, the Independent Expert Report, there was a bit of a complaint that the common law persuasion is overrepresented at the court, of course. So there was also the need to ensure a balance, because Karim Khan hails from a common law jurisdiction. So there was also the need to have a deputy who is from a civil law jurisdiction, or at least other major legal systems. So in the end, Mr. Niang was elected, who is a man from Senegal. And then Ms. Shamim Khan was elected, who is a woman from Fiji. But if you look at, so for me, what is quite notable there is if the prosecutor wanted to ensure that the list that two women got elected as deputy prosecutors, then I would have suggested, or I wonder why, for instance, the candidate from Guatemala, Ms. Bailey, was not included in both list A and list B, because she was only included in the list that in the civil law list. Because that is pretty much a discretionary power of the prosecutor. He submits the list to the ASP, and then the ASP votes. But he submitted a list which included list A had 3 women, and then list B had 1 woman and 2 men. So I do not know of any rule or any law that prevented him from including Ms. Bailey in both lists. And I think that would have increased the chances of 2 women deputy prosecutors being elected in this. So in the end, I think that the effort to increase the gender parity at the top echelons of the court sort of failed in this instance. And then, of course, if to loop that to the other elections during ASP 20, we had the election of the advisory committee on the nomination of judges. In the end, 6 men were elected. In the end, there were 6 men elected and 3 women elected. So in that regard, again, of course, the ASP failed in that regard. Then the trust fund for victims. Also, we had elections there, and after the departure of the former chairperson of the TFV, Mama Koite Doumbia, in the end we have 4 men on the board and 1 woman on the board. So I think, to me, it appears as if the states are pretty much paying lip service to this, because there's a lot of documents being issued by states, the ASP, individual states, and the ICC itself. Our commitment as an institution, or our commitment as a system, the Rome Statute system, to ensuring gender parity, particularly at the top echelons of the court. But then in this case, I think this was a missed opportunity. And the second thing that was quite notable for me was how many states actually voted during this election. Last year's election, Karim Khan's election attracted almost every single state party to the Rome Statute, all 123 of them. Probably there was just one spoiled voter during one of the rounds, but all of them showed up to vote in one way or the other. But in this case, we only had 90 states voting. Well, of course, I'm aware that 8 of them could not vote because they had outstanding arrears, and 1, of course, got an exemption. But that still leaves over 20 states who did not bother to show up. Of course, we have to acknowledge that this is happening in the midst of a pandemic. But the ASP 19 last year was right in the middle of a pandemic, but they all managed to show up in New York. So it's not a question of, to me, I don't think it's a question of capacity really, but it's a question of what states consider important. I think after the election of judges last year and the election of the prosecutor last year, most states simply figured, well, we don't really have a dog in this fight. I think the deputy prosecutor to us doesn't really matter, because it's the prosecutor who calls the shot. So that sort of apathy to me stood out quite significantly.
Great, thank you. And Brianne, just to follow up on this, we're talking about the election of a deputy prosecutor, the importance of having at least 1 woman in that role. Obviously, you don't need to persuade me that that is important, but for our audience members, can you explain a little bit why do you think it's important to have a woman in a role of deputy prosecutor in this climate, to say it that way, where the main prosecutor is male, the registrar is male, and the independent expert review itself clearly identified gender parity as an issue in leadership roles at the ICC?
Well, I think there's so many reasons for that, but I think the most obvious reason is you can have systems in the world that only elevate 1/2 of the population, actually less than half of the global population. Let's just start from there. Apart from also the professional reasons why you actually need all aspects of society, all segments of society represented in some of these institutions. Then the ICC is a global institution, not universal, but global institution. So it has to really reflect the population, the global population as it is, apart from the professional aspects of it. And then if you look at the crimes that the ICC deals with, the atrocity crimes that the ICC deals with, how exactly do they affect victims? So the court has had a problem. If you go back to the early years, the court has had a problem with its interpretation of basically how it approaches gender-based violence as an international crime. And consistently through that, you realize, I mean, it's been studied quite a lot by very many people, but then you realize that some of these things, so the problem that the chambers and probably the OTP might have in properly interpreting the Rome Statute provisions on gender-based violence is simply because we have very many people in there who do not care one bit about the gender dimensions of the law. And that's just one reason. But then just going back to what I mentioned in the beginning, we do not have to go as far as that. We simply have to look around and see what kind of world we live in. Less than 0.5% of the global population are male, or rather identify as such. So if you ever need any reason, I don't think we actually need reason to actually justify why we need 2 deputy women prosecutors. We don't even have to justify that.
Brianne, I think you would
and maybe added to that, I think I 100% agree with what Owiso has said, but I would say we can see there was a stark difference between when Prosecutor Ocampo led the courts in terms of the prosecution and Bensouda. There was a very clear shift in terms of the emphasis on gender-based violence, on prioritizing gender-based crimes, and we want to see more of that. I mean, we need to see more of that. We need to see more of the lived experiences of women as victims, And that starts also with women in leadership positions and the compounded harms that are experienced by women and girls in these conflicts. And I must say, I attended one of the side events organized in part by Alexandra Lilly-Cather on intersectionality and international criminal law. And it was really excellent, fantastic speakers looking at the importance of addressing harms at the court from an intersectional perspective. And I can't stress this enough, that this hasn't traditionally been done in international criminal law, and there's a lot of depth that needs unpacking at the court. But what it does is that it will reflect the lived experiences of those victims who have undergone the harms that the court is meant to cover. So yeah, I mean, just to echo what Owiso said, there shouldn't really be a reason, because it's very obvious if we look at our global population. But on the other hand, the reason is that the harms that are pursued and prosecuted should be reflected of the victim populations, and that is certainly what we haven't necessarily seen. But we have seen a big difference and improvements over the years. And hopefully with a deputy prosecutor who is female, but also the commitment of Karim Khan and others, we will see continuous positive change.
Jacqueline, my next question is for you. In addition to these issues and discussions that our panelists have brought up so far, are there any other developments that you would like to highlight for us from this year's Assembly of States parties?
Okay, thank you, Melena, and to the rest of the panelists and the people who join in. I'm so happy to be part of this panel for follow-up on the ASP. Some of the key points that came out from these discussions included cooperation of state parties. And I think the ICC had challenges of cooperation from state parties who had signed to the Rome Statute. And when it comes to the issues of the court, they don't cooperate much. And drawing from the region, I think we had state parties violating the agreement. So the discussions that focused on the 8th of December were specifically asking the state parties to cooperate with the court. And also it encourages, in the context of the court, that member states should improve their cooperations with the court. And this is to address the challenges that the court faces in terms of arrest warrants. And we had seen some of those who are indicted, they just go free to some of the member countries. I think we had the issue of Bashir when he visited Uganda, and there was no arrest for him. And we also had him travel up to South Africa, and there was nothing done to arrest him. So I think this call was specifically for state parties to live to their commitments to the ICC and also to the Rome Statute. I was so happy to hear Slovenia and the Netherlands come out clearly calling for the state parties to enter voluntarily into agreements with the court. And I think these agreements could probably strengthen the work of the ICC and also help other member states who are still doubting to start working towards strengthening the work of the ICC. I think also other critical issues that were raised regarding the ICC work in the areas of agreements. In terms of victims' protection, I think we had victims who are not protected when the ICC will be doing their work. Drawing closer to Kenya, I think some of the victims, they faced intimidation, and some of them probably lost their lives. So victim protection was very important. And I think state parties were encouraged that they should have mechanisms where victims could be protected. And this comes, I think, closer also to some of the international tribunals. And it will shape way of how these international tribunals will be shaped and to become victim-centered so that victims and their families are more protected. All the speakers underlined the importance of the cooperation, and I think also relocation of some witnesses or victims who could be at higher risk in their countries or where they are. The session also focused on the field of financial investigations And I think human rights is shifting from violations of the armed conflict to also financial implications of probably money laundering that could fuel violations of human rights. So corporate responsibilities become very important to the ICC, and identification of assets, freezing of assets become very important to enforce the cooperation with the ICC. I think those are some of the key major points that came out, but underlying is cooperation.
Thank you. And Jacqueline, just to follow up, I know that you participated in a side event on the situation in South Sudan. Are there any highlights or takeaways that you can share with us?
Yes, there are a lot of interesting discussions around the South Sudan. And as you know, South Sudan has the peace agreement with Chapter 5, which is talking about the establishment of a hybrid court. So the panelists also discuss about the South Sudan government to further establish the hybrid court. This had been an issue which was very sensitive and still remains sensitive, and the slow process had not started. Just for a workshop recently and reflecting on what happened at the ASP, probably priorities may differ and the hybrid court establishment may not be a high priority. So this discussion focused on encouraging the government to expedite the process for establishment of the hybrid court. The panelists also compared the road to accountability from the South Sudan and also the one in Uganda. As you know, the Uganda had the High Court established to try cases. So how do we also look at some of the lessons learned from Uganda to improve probably domestic jurisdiction for the many cases in South Sudan, and also learning on how to improve the hybrid court operations. I think also victims' voices were very much underlined. In Uganda already there are victims groups that participated as witnesses. And as South Sudan is taking the shape in establishment of these mechanisms, the government just announced that the Ministry of Justice should go ahead with the establishment of the transitional justice mechanisms. I think having victims' voices in this process becomes very important. And their voices in the process, but also in the trial and testimonies. And I think this goes also back to what I said in the beginning, like protection of witnesses. So all these are very important, and I think there are lessons learned on how South Sudan can move the transitional justice process forward, and also the call to expedite the establishment of the hybrid court, which had been overdue. And I think this also goes to the African Union to come in handy to support the government in this process.
Thank you. Jennifer, I know that you also participated in some side events last week at the ASP or in conjunction with the ASP. Can you tell us a little bit about those and if there are any major takeaways from the side events that you organized, attended, participated in?
Great, thanks, Milena. Well, I did participate in the cyber one that I mentioned, but already there was another one that I helped organize and spoke on. It was entitled "When Vetoes Prevent Accountability, a Critical Examination of Blocking ICC Referrals." And I had the privilege of having Justice Richard Goldstone also as a co-panelist, and Hans Karel, who was, of course, the top UN legal advisor for many years. And the event was co-sponsored by Canada, Netherlands, missions of Costa Rica, and Sierra Leone to the UN, and Parliamentarians for Global Action. So the panel focused on the veto blocking a referral of cases to the ICC. And what that really means in practical terms is really kind of, continuing cycles of violence. There's, no deterrence created because it's basically a green light, to perpetrators. There's no jurisdiction over you. And I think the increased violence fuels IDP and refugee flows that has increased needs for humanitarian assistance. So it's quite real. And we focus somewhat on the veto of the Syria referral. And of course, we won't have a Myanmar or referral related to the Uyghurs, and it's all because of the veto power. From a legal perspective, I talked about the legality of such vetoes, which is featured in my book, which is now in the chat. Thank you to PILPG for putting it there. So I basically focus on if there's ongoing genocide, war crimes, crimes against humanity, does the veto in those circumstances measure up to use Kogan's obligations, the purposes and principles of the UN Charter, and treaty obligations, such as those in the Genocide and Geneva Conventions. I don't want to go on too long. I'll just briefly mention one other side event I was able to attend that I thought was really terrific. It was hosted by PGA and Switzerland, and it was entitled Reforming National Nomination Procedures for ICC Judicial Candidates, from the IER report to action by the ASP. And it's basically the situation that there really hasn't been national procedures for picking the best judicial candidates, and the fear that those selected, who may be terrifically qualified or not necessarily, are those who, have connections to the executive. And there's really a call that states need to implement a procedure for, calling for submissions, advertising, getting applications, vetting them, having go through a process. So states should have a national process for making sure that they put forward the best judicial candidate. And 2023 is another election cycle. So there was really a call, like, states really need to be doing this now to have these procedures in place. For some states, it has to go through legislation. So this really needs to be done ASAP. If they're going to put this in place for the next round of judicial elections. So I thought that was a really good panel, and Switzerland was showcased what they're putting together and their package of how they will do procedures to select nominations. So.
Thank you, Jennifer. We have some excellent questions that have come in from our audience members, so I would like to go to those next. So the first question is as follows. Does the fact that the ASP was following this hybrid model this year allow for voices that are not heard usually to be heard? Obscure NGOs, victims' rights NGOs, individuals lost in the middle of nowhere without time to attend the ASP normally. Maybe I'll direct this one to Emma, since she was the one who was actually there. And we did touch upon this briefly previously during this discussion when I asked you about, what your impressions were about such limited attendance. But what do you think about the different groups' ability to participate in this hybrid format?
Yeah, thanks, Milena, and thanks, Nicholas, for the question. I think it's a very important question. And obviously the hybrid model limits participation of certain groups that would normally be able to travel to The Hague potentially to attend the ASP. Obviously, there's a very limited ability for people to attend in person and to provide the statement. At the same time, there's also not a lot of possibilities to provide remote statements, perhaps pre-recorded statements. However, I do think that the Coalition for the International Criminal Court, CICC, does an excellent job at bringing voices of civil society, NGOs, victim rights NGOs, etc., to the ASP and to be able to provide statements. There have been several statements from NGOs and people generally to voice their concerns and to have their voice at least in some way heard during the ASP. So it's a bit of a mixed answer, I guess.
Great. I have two other audience questions that I would like to get to, but do any of our panelists have another, and anything else to add on this point before I move on to the next question? No? Okay, let me go to the next question. And this one has to do with the new prosecutor. What is the panel's opinion on the first few months of activity by the new prosecutor? For example, I attended a panel where the FIDH called for the reopening of the preliminary examination for Colombia. So what are your thoughts about the new prosecutors, or is it sort of, too early to tell? We're getting into the more, juicy questions. Brianne?
So I need to preface what I say with the fact that I am slightly biased. I have worked with Karim previously at the Yugoslav Tribunal and at the Extraordinary Chambers in the Courts of Cambodia. His actions over the last 6 months do not surprise me. I think he has a vision and he is a doer. And I think people may not agree with everything that he has done, but he's very open and honest about his decision making, why he's doing it, and the limitations of his office. And I think this came across in the press conference that he held. There's a really great Asymmetrical Haircuts podcast specifically on this. And to me, I've spoken to a number of prosecutors at the court who feel energized. They feel excited about this new leadership and the direction that it's taking. And he's not overpromising. He's not raising expectations. He's saying, you know, this is limited capacity of what we have, and this is where the priorities will be. And I think what he's also doing is emphasizing this principle of complementarity, which has always been in the background of the court, and he's putting it to the foreground. So again, like I said, I think I know how he works, and I think it's a positive development. But I can understand for a lot of people that they're, particularly from victim-focused organizations, that this is very different from what we've seen in the past, and it can be frustrating.
Oisa?
Let me just start by saying that it's too early. It might be too early to judge. But so far, I think it's a bit of a mixed bag, and a mixed bag in the sense that Karim Khan has shown some promising, made some promising decisions, and some that are pretty controversial. But so I think the most controversial, in my opinion, is the so-called deprioritization of the alleged crimes by US personnel in Afghanistan. And of course, Karim Khan justifies this based on finite resources and the need to prioritize issues. But the fact that the ICC does not have enough resources is not new. And in this regard, let me pull up something that Karim Khan himself said. Let me read it out. Khan notes that the ICC is not unique in having finite resources, and that no organization, domestic or international, gets all the money it wants to do. It wants to do everything it could. That was an interview that Karim Khan conducted in May with Shehzad Sharania. So this is something not that he knew. When he applied for the job, when he interviewed for it, when he campaigned for it, he knew that the ICC does not have enough resources. So to come back later and say I'm deprioritizing cases that mean a lot to millions of victims, to many people, on the basis that you do not have enough resources, is simply an admission that you probably are having a problem with managing resources, and you might need help, because the situation in Afghanistan is one of the very topical issues around here. Right? And we know when you talk about pragmatism, because that's another reason that he gave pragmatism, there's nothing neutral about pragmatism. It appears, you might say I'm being pragmatic, I'm being realistic, but if you look beyond the buzzwords, there's nothing really neutral about pragmatism, especially when you look at it and you do not see any sense of equity in its application. Right? So I believe that for many people who've been following the events in Afghanistan for the past 2 decades, this is a disappointment. Really, it is. But then on the flip side, I think, looking at the decision made concerning the preliminary examination in Colombia, that went on for way too long. And I think things have to come to an end at some point. So that is one of the very promising decisions that he's made so far. So to me, it's a mixed bag, and I wouldn't be too quick to pass judgment. I think it's a bit too early for that, at least for me.
Thank you. So you mentioned the Afghanistan, which really is related to the United States. The next question here from actually Professor Julie Fraser, who is also involved with the PILPG, nice to hear from you, Julie, is about the US participation this year. There's a new administration in the US, and Prosecutor Khan obviously has stated that he basically will not pursue US crimes in Afghanistan. This question is for Jennifer. Jennifer, do you think that this has changed or will change the US engagement with the ICC, or perhaps the US policy vis-a-vis the ICC?
Well, I do. Obviously the Afghanistan situation was a sticking point for the US, and that set us off down the path of Trump administration sanctions, which I think were utterly reprehensible. The sanctions are gone, and prosecutors Khan's not pursuing US nationals, you can call it pragmatic, you can blame states parties for lack of money. I think it's extremely problematic because you have to see it in light of, Prosecutor Khan is a UK national. The UK torture case was not pursued. Now we have the US torture case not being pursued. And I think the optics do the court some harm here. This has to be factored in. The US doesn't yet have a US war crimes ambassador under the Biden administration. We're optimistic that she will be put in place. And I think Milena knows our dear friend who I'm speaking of, and that will chart, the US in the best foot forward. But it is frustrating, I'll just speak as a US citizen, to see the US both flip-flop in its relationship to the ICC from attack to mild, to support on cases we like. And like, will the US ever just get to, and we support justice? We support this tribunal, and yes, if it might investigate US nationals, we can either do complementary or actually cooperate with the court, because our US nationals also should not be committing war crimes. So it is really frustrating that we go from extreme hostility to support on cases we like, and that's kind of the US range. And we need the country needs to get to a different place. I don't know quite how to get it there, but we do need to get there.
We have time, we're running up against time, but we have time for one last question. And I would just ask our panelists to be briefed in their answers so that we can actually finish on time. But this has to do with judicial nominations, which we already mentioned. The question goes as follows. I'm wondering if states were generally receptive to the idea of bolstering national nomination processes for judicial candidates. It seems like a problem not of the structure of the Rome statute with respect to the qualifications of judicial candidates, but with the deliberate politicization of these processes. And I think, Jennifer, I think you're the one who mentioned this side event. So was that discussed?
Yeah, I think it's a little concerning that we don't have states kind of leaping at this issue. And the question of the person who posed the question is absolutely correct. This really isn't an ASP, but we can deal with ASP procedures, etc. And we did, I don't know how you ever eliminate horse trading. And I think that's just going to exist. But the point is, horse trading is going to be less if all candidates are well qualified. So maybe that's the best that can be done. Yeah, I thought it was a little concerning. We have one state saying, this is the procedure we're proposing, and the clock is really ticking, that other states really need to get behind this. I know OSJI has been working on this issue for really years and years, and it has great expertise in this. And PGA is also working on this and pushing for states to do this. And the clock is ticking. So I don't see them lining up to do this. It is mucking, their internal procedures. But if you want to have the best candidates, you can't simply have, the judge who works in war crimes who happens to know the person in the executive making the nominations. Like that seems to be how it's been working. And that's just, that's not a sound system. So it really does go back to the national process.
Thank you so much, Jennifer. Unfortunately, we're out of time for today. Thank you for joining us and submitting your questions. The webinar recording will be available on the PILPG website and shared with all the attendees on Zoom via email. I would like to reiterate that this event was part of the PILPG Thought Leadership Initiative Expert Roundtable series. We organize monthly expert roundtables and share our expertise and insights on various topics of international law and international affairs. Thank you again to our panelists for sharing their stories and their expertise, and to all the attendees for contributing to this crucial discussion with their questions. I encourage everyone to follow this initiative and join us for the next event. Thank you.